wish to share public input to be read at the hearing can either post it in the comments section on YouTube or email their input to communications@chester.ca. That's communications with an Chester@.ca. We acknowledge respectful comments relevant to the issues being discussed. Members of the public registered to speak during the hearing will have 5 minutes each to share their feedback. Please state your full name and community for the public record when you have the floor. Speakers are in order according to when we received their submissions. So, Mr. Lamy, you satisfied this matter is properly before council?
Yes, I am, Mr. Warden.
Thank you. Overview by the planner, Gareth.
Hey, good evening, everyone. So, so what we have tonight are a package of amendments that would permit and regulate illuminated signs in the highway commercial zone here in the village planning area. I'll give a quick overview of the amendments themselves, and we'll be happy to answer any questions. In short, this, as I said, it is a package. We kind of tackle this issue from a couple of sides. So we've done some smaller changes like clarifying that exterior lights that are projected onto a sign, that's not considered illuminated signage in terms of what we're talking about this evening. So we've made a few little changes there to definitions and that kind of thing. But the bulk of the package is going to be contained in the land use bylaw and will essentially introduce illuminated signs as a new option in the highway commercial zone. The way that's going to work is we have existing categories of signs, so ground signs, wall signs, window signs, that sort of thing. Those signs will all be able to be illuminated now. So the way that works is you have to meet the rules for whatever type of sign you are, ground, window, wall, and then you also have to meet the new rules that we're proposing for illuminated signs. Just to kind of touch on what some of those regulations are, that basically the size and height limits are proposed to be changed a little bit from what is currently permitted in the highway commercial zone. So the proposal is to allow a ground sign to 6 meters in height in the highway commercial zone. Previously, that was limited to 4 meters. However, in 2012, those signs were permitted to be 8 meters in height. So in 2012, we had a package of amendments come in that prohibited illuminated signs and brought down the size and height of existing signs. And so what we're doing now is a step back towards that, but not the full step. So the height would be limited to 6 meters, which is just under 20 feet. In addition, we're proposing that a ground sign can be larger than previously permitted in the highway commercial zone. In order to have a ground sign that is larger than the previous limit, which was 6 square meters, there is a new requirement to create what we call a landscaped area at the base of the sign. We discussed that with council, and the council was in favor of adding that option in. And so the idea is there to try to soften the impact of the visual impact of the sign. So the landscape area will be equal to twice the sign area created around the base of it, and it will be a mix of flowers and shrubs and other plants to hopefully improve the visual aesthetic there. In addition, there are regulations for illuminated signs regarding the intensity or the brightness of the sign. So we have a formula, and basically you take a measurement from a particular distance, and the sign shouldn't exceed the unit is 3 lux is the unit of illumination. So there's a specialized handheld meter that we'll have access to if we need to test those. We've also asked that any illuminated signs would come with a letter from the producer or the installer to basically say that it will comply with the regulations. There, again, a couple of other changes. Illuminated signs, we're going to require a 2-meter setback from property lines. So thinking there is to basically make sure that we're outside of any public road right of ways and not overhanging over a property boundary for any sort of liability issues in that sense. Additionally, we've implemented any illuminated sign must remain static for 60 minutes, so for a full hour before we can change.
Yeah.
When we were discussing last year changes that allowed Tim Hortons to go ahead and do some drive-through menu board signs, that was part of the discussion, was around how frequently they should change. In those cases, we allowed those signs to change much more frequently, as that was their intended use. In this case, there was a lot of discussion as we worked through planning advisory committee and public information meeting around distraction to drivers and that sort of thing, not wanting to have flashing signs. And so we've put in that limit of an hour. There is an exemption for signs that show the price of gasoline or temperature or humidity or other features like that, or a clock. So if you had a clock, it would be kind of silly to say that it can't change except every hour.
Same as temperature.
So we do have an exemption in for those types of things. And I think that
Yeah, we pretty much.
sums it up. I know we've discussed these for quite a while here at the council table. So with that in mind, I guess I'll just move on quickly to sort of the process that we've gone through in terms of meetings and advertisements for this. So this file originated July 15th, 2021. There was a petition presented by Councillor Barkhouse, signed by some local business owners who were requesting this change to allow illuminated signage. So council at that point gave us direction to prepare a report and return with options. We held a public information meeting on November 24th, and then we're back at council for first reading on January 27th. In terms of advertisements, we followed our standard advertising process with the progress bulletin, as well as on the municipal office doors and on our website. And so that was November 17th, February 9th, 16th, and 23rd. And we did our standard practice of notifying the village, Chester Village, of this public hearing this evening. So I think with that, I will turn it back over, but again, happy to answer any questions.
Anybody have any questions at this point before I move on to the public input? So there is no presentation by the developer because there is no developer. So we have comments by the public, and I know that we had some.
Liz Fraser has joined.
I can't see them. I guess that's my problem.
Are you ready to hear from Susie?
Yes, we are. Yeah.
Okay. We'll put her in the room. There. Okay, Susie, you can go ahead.
Still don't see her, but I assume she's there someplace.
She is.
Susie?
Here she comes.
Yeah. Evening, Susie. Can't hear you.
You're on mute.
Any better?
Yeah, now we can hear you.
Okay. I just was interested to listen in because I sat in on that meeting with Garth back in January, I guess it was, and I would like to go on the record as I don't agree with this. You know, the fact that you're saying that we're going to allow 6 square meter sign, and in the same breath saying, well, we're going to make it prettier by making the landscaping be twice the size. So you've already said that what we're doing here is ugly. So we're going to try and soften the blow by allowing the landscaping. So it just seems like a bit of a double-edged sword in that respect. And I just, there's still residents that live along Route 3. So even though you're limiting the brightness, it's still going to be in their face. I mean, there are residents in the Route 3 commercial zone. And I just wonder if they are aware that this is transpiring. So that's my concern. And I think it really sets a bad tone for the village. I mean, why it's necessary, I just don't know. People come to Chester because of its quaintness, and it is a seaside village, and it's not neon signs. So that's my concern.
Thank you, Susie.
Without directly responding, just one note, because it's a good question. There, one piece of the amendments that I didn't mention, but I think is relevant to what Ms. Fraser just brought up. We do have a piece in here, basically to address those properties that are residential in residential use. And so there's a couple of pieces here. One is that not only are these signs only permitted in the highway commercial zone, but they have to be within the yard that abuts Highway 3. And what that means is between the front wall of the building and the roadway.
Yes.
So it won't allow it around the side or the back of these highway commercial properties. The other piece is that if an illuminated sign is proposed within 30 meters, and that could be horizontally or across the street, it doesn't really matter in any direction. The property owner, the sign owner, basically, and the way this is worded is a bit general, but they would need to show the development officer that they've met the standard. It says the owner shall take measures to reduce light trespass and overspill onto adjacent properties, and that could include the installation of fences or vegetative barriers planted or positioned to provide maximum screening to produce light or to reduce light trespass. So it's not saying that you won't be able to see it, but the intent there is
To try to limit.
more than just soften it, but really to put the onus on the sign owner to lessen.
Okay, thank you, Garrett, for that clarity. So Jennifer, we're on to do, you have the second person?
No, no one else is in the waiting room.
I thought we had 2 or 3 other people who wanted to speak.
Dolly Hancock.
We had 2 more, but they opted not to join, I think. There's no one else waiting. No one else joined.
No one else joined? So that's it?
Yep. I sent them each an email to let them know that we had started, but they
They haven't joined. Okay. Well, if that's the case, then it's that's the end of public input. So I know that we had a presentation last council meeting from Hassan, and it was something just to the effect of it being 2 inches of variation or something like that. So I don't know if you go, well, I would like for you to address that.
Yeah, so it's a bit awkward because typically an application is not something we would discuss in public, but because the applicant has brought that information forward and I've been asked to respond, I'll do so. So we do have an application for a sign at the Irving. And that sign as proposed is 20 feet in height. That's what's shown on the drawing that's been submitted to us. Again, just for a recap here, what we have currently in the proposed amendments is a height of 6 meters, which is 19.69 feet. So it is a matter, he was correct in saying it is a matter of inches, less than 6 inches.
Mhm.
That said, his application as it stands now will not be approved because it doesn't meet the height limit. So where does he go from there? There's a couple of options. Obviously, I guess, first that occurs to me is if it's possible to size that sign down or bury the base so that the height, because we do measure from the top of the sign to grade. So if you can actually bury the base a few more inches, that likely, I mean, the development officer will confirm this, but that is how we measure things, so that should be fine. The other option is that there is always the option, virtually always the option to apply for a variance. Yep. So again, that's something that the development officer will review and either issue or deny. When she is looking to issue a variance, there are a couple of situations when she cannot issue a variance. That comes out of the Municipal Government Act, and it is when the variance violates the intent of the land use bylaw, when the difficulty, and this is a little odd, when the difficulty experienced is general to properties in the area. I don't, in terms of a sign, that's going to be an interesting one, and I don't want to prejudge anything for her. The analogy that I would use there is if everybody's building on a hill and somebody applies for a variance because they want to get higher because they're impacted by that hill, well, all your neighbors also have to deal with that. So that would likely be that kind of a scenario. And the third piece is that the difficulty experience results from an intentional disregard of the land use bylaw. So that would be almost if you did something first and then came back and asked for permission in hindsight, you can't bring it up first. So those are all pretty general. So according to those, I think it would be valid to apply for a variance for the height of the sign. Whether it's approved or not, I can't say that. But what I will say is that if the development officer rejects the variance, the applicant does have the right to appeal that decision to this council, and council can make any decision that the development officer would have made. I guess that's what I would say to Hassan, is that there's the option for a variance. If it's possible to size down the sign, then you don't have to deal with the variance. And I guess the third option, if council felt it was appropriate, would be to increase that height limit.
Yeah, so just let me get this straight, because I'm missing something. So currently it's 6 meters, which you're telling me it equals 19.69 feet, and his is 20 feet.
Right.
So it's like,
5 inches.
Yeah.
yeah,
5 inches.
yeah.
And I mean, the issue is if the drawing showed 19.69 feet,
Yeah,
I mean, obviously the development officer can prove things and
Oh, yeah,
check things on
that's
the
right.
ground, but that's the issue, is we wouldn't be able to issue a permit for something that directly said was
no.
greater than the.
Yeah, my understanding from him, because he came into council, was this is a design built by the company itself, and they don't have numbers.
Yeah. That's not my understanding,
Okay.
but I don't really want to get into that. I spoke with corporate Irving, and there are options for smaller signs. They do come at an increased cost. So I think that's probably where our discrepancies are coming in. Is it possible? I believe it to be, but it may well be that the significant additional cost, and those are the standard size signs. If you look around at other Irvings, you'll see there are different sizes of them, but you do see that they are quite similar.
Same.
Gary, I was wondering, is it the size of the sign or the height of the
The
sign?
height.
Height on post, so you can shorten the post by 5 inches.
He might be able to do
So it's not,
that.
yeah, it's not really the sign size.
No, it's not at all the sign size.
It's how high it goes. with the
Yeah,
air.
absolutely.
Oh,
Yeah.
well, I can't see changing the post length to be that big of an issue,
Well,
but I don't know.
the design of the sign, it doesn't look like a conventional post with a sign on top. It's sort of like an integrated structure that is thick at the bottom, so
Yeah.
it's not like a piece of HSS tubing that comes up with a sign.
Yeah,
So it may be, you'd have to be custom designed potentially, but my view is that this, not significant or anything, but my view is that there is an opportunity within our existing bylaw to make an application for a variance.
yeah.
And
it
should
doesn't
that variance fail, he can then,
Come here,
he can come here, and if we feel it's not a problem, then we can grant
yeah.
his application.
And it seems, well, I mean, I don't want to prejudge it either, but there may be something I'm missing, but it seems like a relatively minor variance.
Gareth, a few questions.
Sure you can.
Gareth, I'm concerned with the closeness to neighbors, and you said there are some safeguards there, but there are some residents right on the highway, not on the backside.
Yes.
So if I own one of those houses, I think someone can still come within 2 meters of my property line.
So there's a couple of requirements that will all work together. So yes, there is a 2 meter setback from any property line. But there's,
I'm more concerned with the residential residences in that zone. Not so much concerned that Irving might be going on to Tim Hortons, the
Right.
commercial. I'm not worried about that.
Yeah,
much
right.
as the residents.
right. So, okay, so in that case, there's 2 things that I would point you to. There is a requirement that the sign must be placed in the yard which abuts Highway 3. And the yard is defined as between the main wall of the building and the roadway. So what that does is it keeps the signs close, addressing Highway 3. So you can't have in the case of,
You can't move it down.
right, you can't put it at the back of the lot or the back side of your lot. It has to be in that front.
Right up in front of your store.
Right, between your front wall and the roadway. So that will help in terms of the properties that are at the back. But to your point, there could be a residential property adjacent to.
Right across the
a
street,
commercial
which
property. Yeah,
will
right.
get a direct impact.
And so in that case, what we have here is that provision that I read earlier. So if an illuminated sign is proposed within 30 meters of a lot that is not zoned highway commercial, the property owner shall take measures to reduce light trespass and overspill through the installation of fences, vegetated barriers, which are fences or vegetated barriers, which are planted or positioned to provide maximum screening to reduce light trespass.
Or controlling the brightness of the sun.
So all we have in that aspect is a formula which says that the sign brightness shall not exceed 3 lux when measured from a distance according to
Nothing to me whatsoever. I don't know what 3 lux is.
Frankly, I don't either. That's like, lux is like a decibel. So there's a specified meter that will read the brightness. What that 3 lux standard is what I've come across in every other municipal bylaw that I've looked at. And it's the brightness that is recommended by a number of organizations that are involved with signage regulations.
So these signs will be lit 24 hours, 24/7?
That will be up to the business owner, but there's nothing to prevent.
Do we have any control over saying that, from 10 to 6, that they're not on, there's no business going on?
Typically, hours of operation are something that we can only control through a development agreement. I think you could make an argument that the signs are to be turned off when the business is not in operation. But if the business chose to stay open until 2 a.m., then the sign would stay on until 2 a.m. So that may be possible.
Did we ever consider then doing some of this by development agreement? There's another, talked to those in the past, and I know the history, we don't need to go there. But we can't control, if we allow it, we can't control the hours of operation. We have a development agreement, we can control the hours of operation.
Yes, that's.
What about oversized signs? Do we then control oversized signs by development agreement? Look at it, maybe have a proper setback.
Yeah, absolutely.
Was that ever considered?
Not seriously by staff, given the history of development agreements. I'll just be frank, given the history of development agreements, the issues we've just been through with allowing development agreements here in the village. It was something I contemplated as a possibility, but not as a practicality. So if council's interested, I'd be happy to bring back a report.
Well, wouldn't that alleviate some of the concerns that Susie had for impacting on the neighbors, for example? The impact wouldn't be nearly as large if it was only illuminated during business hours.
Yes, I think it would give council more ability to control some of those other aspects. And the real piece to development agreements is if we chose as part of that process, we could have, new policies to speak to development agreements on signs to address some of those.
I mean, I wasn't here from the beginning of this process, so I looked at the public participation questions, and there are some good questions in there with respect to why we increased the size from 4 to 6. And is there a good, I know there was a period of time we didn't allow them in 2012. But explain to me again, it went from 4 to 8, now back to 6. Is that what we're?
Prior to 2012, illuminated signs were permitted. And also prior to 2012, ground signs were permitted to 8 meters in height.
Illuminated sign to 8 meters as well?
I believe so. I don't think it.
Is that home hardware sign illuminated?
It is not.
No, okay, so that would have been with the ground signs, 8 meters.
Right,
That would
roughly
be-
8 meters. It may be a foot, like a.
Yeah, that's sort of the sense. If you want to,
Right.
you want to say, what does 8 meters look
Yeah,
like? That would
yes.
be the home hardware sign, there's no problem.
Right.
So nothing would be that big, it would be 2 meters smaller than that.
Yeah, right.
And what about closeness to highway?
I don't believe there was any setback previously. So if there's no specified setback, it would essentially just be that it has to be wholly contained on the property. That's just sort of, generally, we wouldn't issue a permit for something that crossed the property boundary. But that 2 meter setback from the highway would not have been there in the past.
So is there anything we could put in this by way of amendment that would deal with hours of operation? You don't think we could do that?
I defer to Sam, but I don't believe so. The one piece that I'm maybe possible is to say that when the business is closed, the sign would be off, but But the difference there is we can't say 10 PM, the sign goes off.
Understood.
Yeah, no, I just wanted to be clear on the
If we don't want to reopen the development agreement,
No,
I'd like to see it, well. Not on this one anyway. But could we consider some amendment that would say on during operating hours and off when closed? Is that something we could do? Could we amend that based on this hearing? Would we have to go back to another process if we were to go there?
We would have to re-advertise and rehold the public hearing.
It's a significant change.
Yeah, it would be a significant change in my opinion.
On that point, guys, do we know whether these illuminated signs, do they, can they have variable brightness? Like, so you have brightness during when they're open, and then is there a lesser, like, I'm thinking they may say, we don't want them dark, we're not open, but we'd like to have them at some kind of low level.
Yes, we do have some language in there. It says illuminated signs would include software or other mechanisms to automatically adjust the brightness level of the sign to ambient light conditions. And then this is where the standard comes in: brightness levels shall not exceed 3 lux above ambient light conditions. So,
but yeah, because if it's a really, really bright sunny day, the sign is probably lit up more so than it is if it's a dark
to be
tea.
visible.
So if they have that software, typically if they're closed,
Mhm.
the sign could be toned down to
Right.
so it's visible, but not very bright.
Some of them may do that automatically.
We don't know that, do we? It could be full lit for 24/7 is what you're saying based on this.
Right. The way it's worded now, yes. Yeah.
And that's one of the problems with as of right, as opposed to having some more controls. Respect to the line, Susie mentioned, I agree with her, we don't want these in the downtown area. Where is the cutoff on the commercial zone for this?
In the report, map,
Should they go down into the downtown area?
No.
No,
not as the zone stands now. So in the report on page 5, there is a map showing the extent of the highway commercial zone. I can't say every property has frontage on Highway 3, but virtually every property does, or it lots of property that does. So it is all adjacent to the highway. So unless, and basically, as I worded it in my report, unless there was significant changes to policy or to the zoning, the way this is worded now, these signs are quite clearly only permitted in the highway commercial zone. I've added, as part of these amendments, I've added some policy, but also preamble to the secondary plan strategy to kind of explain the situation we're in right now as we're going through the village plan review. The issue of illuminated signs has come up as a pressing issue for the business community, and in that light, we're making this interim change basically to address this, but that, again, it repeated in the land use bylaw and in the secondary plan, which for all intents and purposes makes it harder to undo or to change. It's written that it is to be limited to this zone.
Is this the map you're referring to?
No, that's a map of existence. So this would be on page 5 in the report. So that's.
Oh,
Yeah, so the shaded properties are the highway commercial zone properties. And I should say, one piece that we didn't talk about tonight was that there are, as we mentioned with the 2012 change to prohibit illumination, there are about 9 existing illuminated signs that predate that change in the bylaw.
Yeah.
And all of the illuminated signs that exist are found within the highway commercial zone, or they're outside the village planning area, one or the other. So that was another, in my mind, a logical reason to keep it to the highway commercial zone. We didn't have to have any exceptions or any grandfathered in some other zone. They all occur in that zone. And I think the reasoning, like them or not, or support them or not, the reasoning for them in this zone is kind of apparent. It's called the highway commercial zone. It's the area where these commercial businesses locate that want visibility, and many of them are either chains or, and as we talked about with the urban, have sort of standardized types of signage that they're looking to use. So I think it's understandable why the existing signs are where they are.
Eric, do you have more, Andre has?
No, sure, certainly. I may come back with another one, but I'm gonna go ahead.
I just had a comment about placement of the sign. Define the placement, it would be between the structure and the road. I think about some of our existing uses, for example, the urban, where the sign is not between the structure and the road. So would they be able to replace their sign in the current location using this?
So what, the way that front yard works is it's, trying to think, I wish I had a diagram to show, but it's, if you take the front wall of the building, you would extend it to the end to either so you see, it doesn't have to be directly in front of the building, but it has to be between the front wall and the property line.
The plane, front wall.
Right, thank you. Yes, the plane of that wall. So,
Okay, so we're under the angle.
right, so we're, you know, let just, for example, let's say your front wall was 20 feet from the property line, you would essentially, anywhere within 20 feet of that line, you would be able to put your sign. But it can't go to the side of the building or the rear of the building. So
You have a long slender lot. It really does go to the side of the building.
yeah, and there are possibilities where it could, that provision could make it difficult, I suppose, for somebody to, you know, to meet those provisions. We addressed that in terms of the landscape area. We had thought about that, for example. And so there is an allowance that the landscape area, ideally it's created at the base of the sign, but if not, it's created elsewhere on the lot. But the sign itself, for the time being, at least, we have kept that, and it does have to be between that plane.
And the setback from the property line of the wall is
It's 2 meters.
2 meters.
Anyone else, questions, comments at the moment?
I should also note, I guess, because we've been speaking about it, that setbacks would be something that could be applied for variance as well. The piece about having it in the front yard, that's not variable, but the set, just like any other setback, you can't
You can always
apply for variance.
See if then put the sign where his old one is?
There's no requirement that he put it there. Oh,
It's just as long as it meets the bylaw.
exactly, it would just have to be.
Is there any willingness to take a look at this issue of hours of operation? That's sort of want to go back.
Would we have to start over again? I guess I'm just asking that question. Is that a significant enough change?
Yeah, I think it is a substantial change. It's a more rigorous bylaw than it is now. So I would think it's a change that, if you're in favor of it, the proposal, you might not like it. And of course, you're against it,
Yeah.
So I think you'd have to, I think it'd be considered substantial.
And what we don't know, what I don't know, is whether or not businesses would actually keep it on after hours. I mean, that is not known to me. That is a big issue, but they're going to turn it off anyway. It wouldn't be a bad idea to talk to someone and just see about what their intention would be before actually deciding on it. Because I think that lightness, if you're living there, if it's in your eyes 24/7, would drive me crazy for me. I'd like to see some control on that. Mr. Planner, would you have any thoughts on that?
I don't think it's appropriate for me to comment at this point.
Just thought I'd try.
I don't know. I mean, a lot of stores leave their lights on inside just to a degree.
I understand. I understand what the
Street
business
lights
is
are on.
want, and I'm not trying to stymie the businesses. I just want to think of the neighborhood. And I understand it's the commercial zone, but how many of these residential properties? I mean, I drive by there 5 times a day, and I don't count the residential properties on that stretch. There's got to be right on the highway.
We'd like to be a lot less than the street light, but it would be.
Way less than a street light.
I wouldn't think, the street light's all along there, isn't
Yeah.
Well, they'd like access storage one stays lit
Yeah,
all night.
that's right. That's probably a fair point, that many of the existing illuminated signs do stay lit. From my experience, I'm not here all the time.
I don't know if it disturbs the neighbor across the road or other, you kind of get used to it, I don't know. But I do know it stays on. It's one of the older type, but it's,
Like,
It is lit.
I don't want to say anything, but most commercial businesses keep some lighting on all night long. as Protections for the
It's
property.
inside the building.
Yeah, or even outdoor lights,
Parking
lights, yeah, and stuff like that, they just do. And it's for a pretty good reason, man. Keep people from, you can see somebody if they're trying to break in and stuff. Anyway, we have to decide something.
So our options are to make a decision tonight or propose an amendment, that's sort of where we are.
That's more or less where we are, yeah. So I'm looking for a decision to cancel as to which direction you want to go.
Does a week can make a difference if we defer for a week, so I'm just sort of looking into that issue and maybe.
Sorry, so.
I guess,
You can make a decision anytime, just,
Yeah.
this is only this,
But there'd be no more public hearing. This is-
no, it's the only
This is-
counselors that are here.
This is a chance to hear the public, I understand that.
Yeah.
And I know we only have one person up here, but I mean, points were good points. We don't necessarily want to kill the whole proposal, that's not what I'm trying to do here, I'm trying to build in some protection for the neighborhood. And also support the business community. And I did understand that when you went to the village, it just wasn't on the record, that it's not go around through the village. And I think that's important for people to understand when we hear about illuminated signs. So,
Just, if we delay it a week, what are we trying to accomplish?
I would like to get a better sense of what the businesses are looking to. I guess I take a more of a drive to see what residential properties might be impacted next to a commercial one. Get a sense from the businesses that I can perhaps chat with and see if it would be their intention if they were to do it, to leave it on 24/7. I'm not out 24/7. I don't know what they do at midnight to 7. The lights on. And I know there's a bunch there now, so there's going to be, how many more are there going to be? Maybe not that many. How many potential businesses are there that could put up signs?
I don't have the answer. It would be every highway commercially zoned property in theory, but not all of those are in commercial use right now. So,
I just like to hear what other people around the table feel about this.
are the signs that are there now lit all night mostly? I think they are, but.
I think so, but yeah, kind of the same. What I can say is there was, last year when we were working on the amendments for Tim Hortons.
Yeah.
I came in at 4:30 one morning to take photos of all the existing ones and they were all lit up then.
Yeah.
I don't come in every day to check.
No,
Yeah,
no.
so I presume so, I believe.
The majority.
It's pretty common for them to be lit up all the time.
I know the ones in Pepperidge are all lit up.
Well, yeah, most of the ones
The business model stays, that's like.
Yeah, yeah.
I just don't know.
And as I said, that's not the only light in the yard, right? The yards are lit up. I guess it's just that if we're gonna go look, I don't mind waiting a week, but if we're gonna go and look and we're gonna change and make that an amendment, then it's just more time, then we're starting over.
Yeah, I don't really feel I want to do that. And,
I may have an idea.
Oh, well, I'm looking for one, I mean, bright ideas sounds good.
One other potential option is knowing and understanding that we are in the midst of a village plan review.
And you may change it then anyway.
We could certainly introduce a regulation about turning those signs off when the business is closed as part of the village plan review, or revisit the issue entirely if we've decided that.
Well, it'll probably come up during.
So I was just, as somebody who's heavily invested in that plan review,
So I guess sort of like what you're saying is if we pass this, adopt it now, during the plan review, if we determine that there's issues associated with it, in particular, the not turn it off at night or something like that, we could make the amendment and adjust it.
right, it's similar to sort of anything we have today, but I mean, the risk is if it creates a hardship for people, it will be there until plan review becomes effective. So that, I'm not saying it's without risk. That's.
Okay.
A question, so if we approve it tonight,
Yeah,
would not those businesses be grandfathered in, no matter what we decide at that during the?
I think, well, it's an interesting question. Yeah, maybe potentially so. The signs themselves, obviously, if we said the sign height is changing again, you know, the signs. Yeah, actually.
I think there would be, I think,
Yeah.
once they get a permit for a sign.
I
with certain
suppose,
specs,
the time of day wouldn't.
and that's, yeah, and that's where this is a little tricky on the, where we can't regulate the hours of operation, but we're saying you must turn the sign off and the business is closed, because I thank you, Councilor Connors and Sam, because I think essentially that requirement to turn off the sign would be a condition to the permit, would it not?
Yeah.
And so if the permit was issued without that I see, yeah, that's, my apologies that
If we approve this tonight, it doesn't, how to put it, this would give Derek still a week or more to go out and look and do those checks, because it actually has to be approved at a council meeting, right?
The decision of no,
No.
it's proved it once we close it up here, because we are
I
canceled.
I'm
thought,
saying it's council now.
Yeah.
okay, I just thought it might have to go to.
But it could be any council meeting.
We just need to defer the decision for a week to the next council meeting.
We could easily defer. the
I'd say,
decision
I have
for a
no
week.
problem doing that there. You want to look, just putting it off for our next
Yeah.
council. Maybe give you an opportunity to look and see what lights
Well,
are.
I talked to some people, again, sometimes people aren't totally aware, and I was truly expecting more people to be here, and maybe if it was in person, there would be more people here. Is it because they haven't heard about it? You know, I don't know that.
I don't think there'll be a big issue with the tags. I don't, we put streetlights in our community, and there was no, you know, that's a big thing. And streetlights are much brighter than signs.
Mind you, I've taken them out because I guess they
Well, I'd
don't
be
complaining
shocked,
because
I'd
they
be
shine in
shocked.
their eyes.
with my area.
A motion to defer for a week?
I would just say, if I can weigh in, I think that, I think we all recognize that this need to increase the sign off the existing is required, and that's why we're looking at this. And it was 2 months ago or so when we decided that moving it back up to 8 meters was probably not the right move, so we decided at that point to move it back down to 6, and we thought that would be reasonable. Now, we had never discussed the intensity of light or the impact on the neighbors, and I'm not sure what led the council of the day to remove the 8-meter signs at that time, if it was light or height or what drove them. So I don't remember, and I don't know if those who were on the table at the time do remember. But I think there were good points on both sides made. I realize that of course it could be neighbors that are impacted, but we're also in a highway commercial zone where you're gonna have commercial activity in that zone. And so you have to be sensitive to residents, but you have to also appreciate that other commercial activities may also occur in that zone.
We're trying to encourage commercial activities.
So I think having some consultation for a week is not a bad idea, just to make sure that we're not doing something really bad, but I really do feel strongly this is probably the right move for our businesses. And if there's just a subtle tweak and it takes, we gotta go through this process again, that's fine.
But I don't know that the brightness issue has been, again, you've been at this for almost a year now, I just come in. But to me, the brightness issue for residential properties, when the business is closed, is an issue. And I just need some time to.
Well, why don't we just defer for a week?
Giving further thought and kind of deliberating on our own and, you know, walking the streets and talking to individuals and so on. If that's what Derek is thinking himself. Just being a stickler for some things. So we've closed the comments by the public. So therefore, and people are passionate. So therefore, if we have this at a regular council meeting, if you will, which is all of our meetings are open to the public as they should be. People should know, because we don't want to make people upset, that we are not receiving further comments
That's
because we're
correct.
closing the
This-
comments
This
now
is,
at this point in time.
this is finished.
And I remember that very clear from the Salt Canoe public hearings. I was instructed very clearly to not make them error of opening any emails and wrongly listening to further information that the public may provide to me or any of us. So I mean, I was, you know, and that's okay, because I'm trying to follow the rules. So there is a bit of a sensitivity to it in terms of,
Good point.
Yeah. Yeah, the public participation piece is complete.
Yeah. Yeah.
Yeah. Driving around the neighborhood and looking at it yourself is a different matter.
So would it be inappropriate to speak to some of the businesses about their intention? Would that be?
Let's get this technical.
I think it technically would be, and in reality, it really doesn't matter what they say to you because they're not bound by it. In the sense of, you know, and any other owner is not bound by it, so they could all say, no, we're gonna turn them off at
Night, and we
night,
don't.
and then they all leave them on.
that's right.
Because we don't have anything in the.
No.
in
And
this
then I should say they
proposal.
do this deviously, they may, you know.
But to go out and seek public opinion after the public,
Well, that's part of why I'm raising it here. I don't
Yeah.
want to be offside on that.
that wouldn't really be appropriate. No.
But
Go out and look for yourself to see how
You
many.
look for
others-
yourself and reconsider the evidence and so on and so forth, and consider it, that's fine.
Public consultation would technically not be appropriate.
I think I can handle that for a week. Just put on my earplugs and,
Yeah, well, no, for you to go out and look so you can see how many houses are infected, that's one thing, but no, if we open it up, if we.
no, I understand,
Yeah.
I understand. Just,
Okay, so a motion to defer
So moved.
until, not next council, because that's Thursday, but, March 10th, yeah.
Move that we defer it to March 10th. council
Second.
meeting.
Second discussion, all those in favor? Opposed, motion's carried.
I'll drive slow tonight and have a.
Yeah, well, let's take
Yeah.
Anyway, that's it, people, motion to adjourn,
So.
Second.
discussion, all those in favor?